that's all set up in the finding the that plugin tool. Thank you.
So
Good, yeah?
Yeah.
the court is ready, but court rise. Appeal in the matter of Riley and Sivier.
My lady, my lords, may it please you, I appear on behalf of the appellant, Mr. Sivier. My learned friend, Mr. Stables, appears on behalf of Miss Riley. There are, by way of preliminary points, if I could ask first of all, no discourtesy is intended to the court, but if I could keep my mobile telephone on my desk, simply that if any instructions come through from my instructing solicitor who isn't here, I'll be able to see those.
Yes, of course.
Thank you.
Mr. Mitchell, I presume that you and Mr. Stables have discussed the question of timing for the hearing, which is estimated to last for 2 hours.
Yeah. We haven't discussed that, my lady. What Mr. Stables has helpfully indicated is he doesn't take a point in respect of my supplementary skeleton argument.
Well, we'll have to, but still, you have to divide the time
Yes.
between you so that you have time to make your submissions on the appeal.
Yes.
Mr. Stables has time to respond, and you have time to do a reply.
Yes, what I propose, my lady, is that if I deal with my appeal points at the outset, I hope those can be dealt with relatively swiftly, because it is a narrow point in my submission. And then if I hand over to my learned friend to develop the points set out in his respondent's notice, and if I respond to those, obviously that's without prejudice to my primary position in respect to the respondent's notice, which is that the issues raised there are not before the court, but I will deal with that by way of my reply to what my learned friend has to say. If that is suitable, my lady, I propose that we deal with the issues before the court in that order.
Yes.
Very well. And the only other matter, my lady, I understand the court has the additional authority of SOFA and Swiss independent trustees.
Yes, thank you.
Was added to the bundle late. There's a core bundle, a supplementary bundle, and then a bundle of authorities which runs to 15 authorities now, with the addition of the SOFA and Swiss independent case. Dealing with my appeal, my lady, my lords, the point on which we have permission ground 1, failure to apply section 4 of the Defamation Act 2013. The article in question is at the back of the core bundle, and as my lady will see, it is a relatively short article which is published on Mr. Sivier's blog, Vox Political Politics for the People, on the 26th of January of 2019, and helpfully it's been the paragraphs have been numbered within the copy you have, and they run to some 21 paragraphs. As is set out within the judgment of the court below, the appellant, Mr. Sivier, is a political journalist and a disability campaigner. That's paragraph 1, and this is the blog that he writes. The next point I will deal with very briefly, my lady, because I recognise it needs no introduction to this court, is section 4 of the Defamation Act 2013, and it needn't be turned up, but the court has it at tab 1 of the authorities bundle. The points which I will deal with better by response to what my learned friend has to say in his respondent's notice is that the structure of that section at every stage in my submission, calls on an evidential inquiry on the part of the court to determine what is in the mind of the defendant, whether or not public interest is in issue, whether or not the defendant reasonably believed that the statement was on a matter of public interest, and that, of course, has to be tested by reference to Section 4.2, all the circumstances of the case, and further, there has to be due allowance for editorial judgment, as we see at Section 2.4. So my main submission here is that this is a distinctly, inherently fact-sensitive exercise, which is not suitable, save in extreme circumstances, which this case is not, for summary determination.
Can I just ask you, and deal with it at a time that's convenient
Yes.
in your submissions, to address the question of your pleadings on the issue, because true it is that these are fact-sensitive issues. The question is, what have you pleaded
Yes.
in your defence about any of them?
Yes. Well, I can deal with the pleading point now, my lady. The defence is at the back of the core bundle. And if we look at page 154,
Yes.
following on from the Section 2 and Section 3 defences, which are no longer extant, albeit the facts set out in the Section 2 defence would be matters that the defendant would seek to rely on. There is set out, first of all, the particulars of statement on a matter of public interest, and the four matters are set out there, as the court can see, running from start online bullying and harassment, including death threats, through at the end to anti-Semitism. And this, in my submission, deals with the issue at Section 4.1a. Statement complained of was or formed part of a statement on a matter of public interest. We then have the matters concerned with 1b, starting at paragraph 40. First of all, the context to my client's article, the Channel 4 news broadcast, which, as we see higher up the page, in respect of the honest opinion defence, that was on the 9th of January of 2019. And then we have the two articles, one from The Guardian and one from The Times, both on the day of the actual article, the 26th of January. And in addition, we have the fact of the defendant's own Twitter followers and publications to those 600,000 plus followers.
What about what you say in subparagraph 2? Because one of the issues the court might have to consider on a bonic basis is what the defendant was intending to suggest.
Yes. And
is that what we find in subparagraph 2?
Yes. It's, as I say within my supplementary skeleton argument, when it comes to trial of this matter, the necessary context which the defendant will be addressing is what he considered was a counter-narrative to that which was set in the national media, whether the broadcast or print media.
Well, it doesn't really matter what he thought the nature of what he was saying was, does it? Whether it was a counter-narrative or what it was. It might matter whether he had some meaning in mind which was different from the one that Mr. Justice Nicklin has determined was actually born. And I can't see at the moment, in paragraph 40 or anywhere else here, any clear assertion that he did.
Well, the matters that we don't find within the imputation meaning are, as I've just mentioned, the wider context to the story of online bullying and harassment. The claimant the defendant set out in the first 6 paragraphs of his article a summary, a fair summary of what had been said by the claimant, both within the Guardian article and more generally about her experience of such online abuse. And he then set out what he considered was an alternative narrative in which she was cast not as the victim, but as the perpetrator in respect of the teenage girl with anxiety, who suffered anxiety, Rose. So that is a matter, the wider context, which he will, in his case, it is part of the publication. And further, there is the issue which he addresses concerning the disparity in power between the child, who's a vulnerable person, not just by the fact of being a child, but also because of her mental health.
But you make the point that the statute provides a defence in respect of the statement complained of and not the meaning, which is correct. But it still has to be the statement complained of, not some other statement.
Yes.
And it's not really relevant to say, well, it was in the public interest to talk about things that aren't pertinent to the meaning. Just can't provide a defence to the meaning.
Well, the public interest is the public interest is set out as we just look within the pleading, the 4 matters that are there identified, and then the inquiry at trial would look at the belief of Mr. Sivier and whether or not that belief was reasonable. And relevant to those matters are issues which are obviously not within the statement as found by Mr. Justice Nicklin, not least because of the wider issues concerning hypocrisy, whether to do with anti-Semitism, separate from any issue to do with online harm. And then there's also the role of the other celebrity, who initially had indicated that she would be proceeding with a claim against Mr. Sivier, but didn't issue in the end, Miss Oberman, and what is said to be the connection between the claimant and Miss Oberman.
The point I was trying to make to you is that the statement complained of is to be found in the particulars of claim.
Yes.
Not other parts of the article. And so that's what you've got to defend. If your client's case is, well, I said a lot of other things that I thought were in the public interest, that's irrelevant. And if his case is, the statement complained of bore a different meaning, in my mind, from the one that the court has found, then he's got to say so and defend that meaning as something that it was in the public interest in his mind to convey. So, I repeat, I cannot see in the pleading as it stands the statement of what it was that he thought he was saying in the public interest that arises from the statement complained of.
Yeah, well, to the extent, my lord, that matter needs to be identified, then that is something that I seek permission to do. It would be a brief amendment, and the gist of that, although I'd obviously need to take instructions, would be to reflect those wider issues which don't find expression in the imputation meaning as found by Mr. Justice Nicklin, which some of the points I've just touched on, to do with the wider context regarding this story. And further, my lord, I'd suggest that it, in terms of the parameters of this defence and what was said most recently by the Supreme Court in Seraphim, looking at the evolution of the section through the parliamentary stages, in my submission, it has to be the case that, notwithstanding the specific words identified for complaint by the claimant, the wider issues set out in the article are necessarily part of what the defendant had in mind when publishing the statement. It would be artificial to constrain him to those specific words that the claimant has complained of, without reference to wider matters such as the role of Miss Oberman. So if that...
But if he wants to defame Miss Oberman in the public interest, that's one thing. But if he wants to defame this claimant in the public interest, then he's got to justify that.
Yes.
Justify in the conventional sort of ordinary language sense. He's got to defend that as something that was in public interest.
Yes, and that, my lord, is touches on the points which are set out at my paragraph 39, because all of those matters go to the justification of the words concerning the claimant, as distinct from Miss Oberman.
Yeah. Okay. Sorry. Thank you.
And then, in terms of and obviously, I have no doubt, in response to my learned friend, we'll be looking at the parameters of Section 4 again. Just in terms of how the matter was dealt with by the judge below, the Section 4 was not referred to specifically in the application notice. It was only mentioned as I term it, a catch-all, separate from what was said about Section 2, and for that matter, Section 3.
Can you give us a page reference
Yes,
for the application notice?
So that is within the supplementary bundle. That is A83. My lady will see the at paragraph 2 there, grounds for striking out the defence in its entirety, or alternatively the paragraphs above. The specific paragraphs to do with the Section 4 defence were not mentioned. And then within the written submission below, that is at page, it starts at page 254.
Can you give me a tab number?
Yes, it is at the exact page is 269, and the tab is 21. And you'll see that it was dealt with by my learned friend in the in his paragraph 71 in the single sentence we have there. And as I've said within my supplementary skeleton, the contingency of Section 4 based on Section 2 was a point that I took below, and I understood my learned friend had accepted as being wrong. And then within the judgment, the analysis and decision to do with Section 4 is dealt with very briefly, and that's at paragraph 68 of the judgment. And the points that I make, my lady, my lords, in respect of what I say are the errors of law in the judge's treatment of Section 4, can essentially be summarised as 4 points. The first is that the judge didn't address the section itself or the pleaded case on behalf of the defendant. And the second point is the point I've just mention that Section 4 isn't contingent on Section 2, truth defence. And as I say, within the appeal skeleton argument, that was considered by my lord in the case of Doyle and Smith, namely that...
Are you saying that's an invariable rule, or does it depend on the nature of the case and the particular facts that are relied on in a defence of truth?
I don't see, my lady, it's an invariable rule because going back to Reynolds, one of the issues that will be live is how the veracity of any particular matter was judged by the defendant at the point that he published, and obviously that's a matter that can go to the second and third issues within Section 4.
But here we're dealing with quite a confined set of factual circumstances on whether one looks at it through the claimant's or the defendant's lens, which is what happened in the Twitter sphere, as the judge described it.
Yes.
That's really it, isn't it, so far as facts are concerned?
Yes.
Because the claimant himself, the respondent says, or I should say the defendant says, that he, having looked at the articles, he then went, for the purposes of Section 4 defence, he says he went and looked at the tweets.
Yes. And that, so I agree, my lady, that at trial, the compass of evidence would be narrower than it might be in other journalism cases where Section 4 is live. And one only has to look at the detail of some of those cases in which my lady has been involved, my lord, and the length of those judgments to see the extent of the factual inquiry in those cases. And I don't suggest that this would be as extensive. However, that doesn't recommend that this is a case more suitable for summary determination. For the reasons I set out in my written submissions concerning the judge below, her understanding of the relevant factual compass.
So you were dealing with your second point,
yes,
which is where you said that Section 4 is not contingent on the outcome of the Section 2 truth defence.
Yes.
And referred to Doyle and Smith, and you acknowledged that wasn't an invariable rule.
Correct.
What are the reasons for saying it wasn't on the facts of this case, given the narrow compass of the facts with which the case is concerned?
Well, for those reasons, primarily within my supplementary skeleton argument, the facts that the judge did not take into consideration because of the selection of tweets that were placed before her. And I should add that whereas my learned friend addressed his case to a schedule which now finds expression appended to the judgment, it originally was appended to his skeleton argument, having been produced by his solicitor. I addressed wider tweets which form part of the appendix to the defence.
So that it wasn't, you didn't rely on fewer tweets, you relied on more.
Yes. And because what the claimant's selection of tweets is confined to direct tweets between her and Rose. It doesn't deal with third-party tweets, and it doesn't deal with either of their response to third-party tweets.
Well, I'm a bit puzzled about this because I thought the judge had taken into account all the tweets from the claimant, from Rose, and from third parties, and from Miss Oberman, that either side relied on as part of the exercise of deciding on the defence of truth.
Well,
is that wrong?
The judgment is confined, my lord, to the appendix to the judgment, which is only direct tweets as between the claimant and Rose.
Well, I don't think that's right, is it? That
Deals explicitly with the, for example, the tweet from Miss Oberman, or to Miss Oberman, I should say, to be more
Yes,
precise.
that is Yes, I'm correct. That
There's a whole section starting at paragraph 43, which is about third-party tweets.
well, what if I can explain it this way, my lord, what we don't have within the judgment is reference to now within my appeal skeleton at paragraph 28. And what we see at A the third-party abuse alluded to in tweet number 13, and then the statement from Rose that she's having a break from Twitter, and then we get to B. The schedule didn't include the further abuse and death threats from followers.
Well, the schedule didn't include it, but what do you say about paragraphs 43 onwards, where the judge starts by saying Mr. Sivier's proposed defence relies on, and then she goes on to talk about the material of Mr. Sivier's pleadings and what it shows about how Rose found herself the object of online attention. That's why I was puzzled by your skeleton argument in this respect. It seemed to me, on reading the judgment, that although you're right to say the schedule that she attaches deals with some but not all of the tweets, that doesn't mean that she ignored the material that your client was relying on. She actually expressly refers to it and deals with it.
Well, I take that point, my lord, in terms of what is said there. What that doesn't equate with, in my submission, is what we see of the judge's detailed, forensic, in fact, analysis of the tweets which were relied on to show that the truth defence wasn't arguable. And there are a number of important omissions from that concerning the relevant chronology, which were matters that Mr. Sivier was cited to when he wrote his article. So put generally, the chronology is thus that on the 17th of December, there were these two dog piles directed at Rose following tweets from the claimant, that further on the 17th of December, the claimant accused Rose of spreading anti-Semitism. Rose then sought to withdraw from the exchange and said that she was taking a break from Twitter. There then followed death threats from followers the same day. This is the 17th of December. On the 18th of December, Rose blocked the claimant, and that is an important issue for two reasons. The first is that the child, as she said at the time, was seeking to escape Twitter and to retreat from the fray because of the abuse which she was suffering. And the claimant, Mr. Sivier will say, kept her central to her followers' attention by not permitting her to retreat and seeking an update, as she told her. And the other reason why...
I'm sorry, just to be clear, are you saying that the judge didn't deal with any of this?
Well,
I mean, what you're now doing is addressing us on matters which I thought the judge had actually dealt with, but the question really was, what had she left out?
Well,
or do we have before us both in the judgment and in the in the schedules the material which is going to form the basis of the Section 4 case.
Well, you have some of it. You don't have all of the tweets in these bundles, but the point I submit is a slightly different one, and it's this, my lady, that from where Mr. Sivier was stood viewing this, and I've got to the point concerning the blog, and that's important because of what is then said about continued monitoring and surveillance of the child by the claimant, and what then follows. There are tweets on the 9th of January in which the claimant places a screen grab of tweets from the child alongside an account called At Labour Against AS Anti-Semitism, which dealt with the recent Pittsburgh synagogue massacre. And so by placing this directly within the context of that massacre, it served to highlight once again the case of Rose, which led to further abuse, a third dog pile, as it's termed and as is pleaded at 24F of the defence. And there is then the Channel 4, this is on the 9th of January, the Channel 4 interview.
Your pleading at 24A is of what?
24F.
24F is of what?
A third dog pile.
And that, but this is all what you said in support of your defence of truth.
Yes.
Which the judge has struck out as not arguable.
Yes, and the point I made.
So we have to be careful about what's said about it.
Yeah.
Because and your application for permission to appeal in respect of that has been refused. And I just found that the causative allegation that is made is not arguably true. So your submissions must be directed to the issue of whether it was in the public interest for you to make the statements.
Yeah.
Not whether they were or were not demonstrable of the allegation which Mr. Justice Nicklin found the words for.
Yes, and I'm seeking to do that, my lady. The point I'm making is that the facts as available to my client at the point he published were the third dog pile, the number of the attention that this tweet generated on Twitter adverse to the child. There is then the Channel 4 on the 9th of January, the Channel 4 interview, and on the 11th there are 63 tweets by Miss Oberman to the child, and the child blocks her, and then this prompts a series of abusive tweets, both at the child and her father by Miss Oberman, in which she suggested that her father had used her, that he was disgusting, and she also sought to suggest that the child was not a child, and in fact was an adult who was posing as a child. And then that leads to a tweet in support of Miss Oberman.
I'm really finding this quite difficult to follow. This is an argument on the facts,
yes,
about what your client had available to.
Yes.
All of this material was considered by the judge as part of her overall assessment of the tweets. So far, I haven't understood your submission that she overlooked things. Right. And she concluded that looking at the whole of it, there was no possible basis for anyone to conclude that what had been said by your client was true. Are you saying that looking at the part of it that your client looked at or relies on, we can hold that it was reasonable, or might have been reasonable, for him to hold the belief that it was in the public interest to publish what he did?
Well, to take that in stages, my lord, notwithstanding the reference in the judgment to considering everything, when the judge comes to analyse the defence, she does that in a vacuum of the matters that I have just referred to.
On what basis do you say that?
Well, because she doesn't refer to the material tweets.
Well, she doesn't have to set out every single tweet. But she, as in the passage I've mentioned to you, she talks about the material in Mr. Sivier's pleadings.
Well,
I don't really understand how you can say, because she didn't actually set out a particular tweet, she didn't have regard to it.
The point, and perhaps if I deal with it this way, my lord, I'm obviously not seeking to revisit the Section 2 defence. That's not before you. But what I'm seeking to do is to demonstrate that at an evidential inquiry as to my client's state of mind when he published, these are the matters that he will refer to. And it is abundantly clear in my submission that there is an alternative view of the relevant tweets from the one suggested within the judgment below, notwithstanding the fact, my lord, that the judge didn't go on to look at the necessary parts of Section 4. Now, my learned friend says against me that it's palpably clear from the judgment below and the materials that were before the court, which are then before the court again today, that it was a decision which could be reached by the judge, and it should be upheld by this court on alternative grounds. The difficulty with that is we simply don't know, save for the very general submissions that I may put together in response to the respondent's notice, what Mr. Sivier will say concerning both what he considered as a matter of his belief was in the public interest, and then the court's determination of whether or not that is reasonable. Now, one looks at the De Freitas case and the point that was made by my lady on appeal about the nuanced nature of the inquiry that was before the court and the detail of the evidence that is recorded in my lord's judgment at first instance, much of which is repeated in the judgment on appeal, and then one looks also, my lord, at the Doyle and Smith case and what my lord held about the plausibility of the defendant's case regarding Section 4 and how that had been comprehensively deconstructed through cross-examination.
Yes, but let me put it to you simply. Let's suppose, because it's not pleaded otherwise, that what Mr. Sivier thought it was in the public interest to say is what the words he used meant, as determined by Mr. Justice Nicholas. And he says, we know this from his defence, I believed it was in the public interest to say that. And he sets out all the tweets that he relies on in support of that. Why can't the court test the reasonableness, not the existence, but the reasonableness? Assume that he holds that belief. Why can't the court test the reasonableness of his belief against the tweets?
Because, my lord, these tweets were part of a Twitter conversation in which there was a context which, save for the bare tweets before the court below, is not set out. And it would be perfectly possible for an individual to read those tweets in different ways. Now, what the defendant will say about his reading of the tweets was that they showed, on the part of the claimant, an unwillingness to allow the child to retreat from the fray, to maintain her directly and squarely in the attention of her followers, who she knew, whilst she may not have been responsible for them, she was cited to the fact that a number of them had directed extremely abusive tweets towards the child. And Mr. Sivier suggests another thing he will deal with is why it was that the claimant saw fit to continue this, if she wanted to continue a dialogue.
But the problem with that is, you've just submitted that it would be perfectly possible for someone to read the tweets in a different way. The judge has held that it wouldn't be possible.
Yes.
So he's bound by that. So he can't run that case.
Well, on the Section 2 case, but my point is a more general one, my lord, which is to do with the complexion that will be placed upon the factual background at trial under cross-examination, as opposed to what is said in the context of the inquiry on a summary determination.
Now, so far as the Section 4 defence is concerned, the onus is on the defendant to plead and prove his case.
Yes.
So he raises the defence, he has to plead the particulars he relies on to support it. And I think what you said earlier, which comes back to a point that I asked you about at the outset, what you said earlier was we don't know what he's going to say, or we don't know what he's going to say about X, Y, and Z. When this is not sort of simply a pleading point, although it is a pleading point, but shouldn't the position be that we should know what his case is under Section 4 on the 3 steps which have to be taken?
The point, and I didn't express the point very well, the point I was alluding to, my lady, is that the circumstance in which my supplementary skeleton were put together in preparation for this hearing was such that it's necessarily a provisional overview of what his case will be, and I explain the reasons for that. I'm not seeking to say he doesn't know what his case is. The point I made.
No, I think you said we don't know, as opposed to he doesn't know.
Right, in which case it was an infelicity on my part. The point, my lord, my lady, really is this, that the public interest is necessarily a broad concept. My learned friend refers to Seraphin in the Court of Appeal at paragraph 33, and there's the off-quoted judgment of Lord Bingham in Reynolds in the Court of Appeal. And then there is a point here as well to do with wider issues which might be brought under the umbrella of matters of political importance. I don't seek to draw an exact analogy with the De Freitas case, and what my lord said at paragraphs 251 and 256. But nonetheless, issues to do with online harm and bullying are of pressing public interest, and I refer within my original skeleton argument to the Law Commission's recent report and the proposals to do with change, specifically legal change, specifically to outlaw dogpiling, as it's called, pile-on harassment on Twitter, and to criminalise it. Further, there is the issue concerning what is said by my learned friend, a suggestion of dishonesty on the part of Mr. Sivier, in that his pleaded case is not one which is open to him, because effectively he would be dishonest were he to give evidence to that effect. Well, that needs to be properly set out in any reply, so that the parameters of the dispute when it comes to trial are clearly articulated for the court, not least for the benefit of Mr. Sivier, so that he is able to prepare and meet squarely an allegation which wasn't taken below and is raised on a collateral basis within a written submission before this court. There are then issues, as I mentioned before, what my lady said about the nuanced and bespoke reasons in De Freitas. That's paragraph 97 of the Court of Appeal judgment. And I mentioned also the issues that turned on cross-examination in Doyle, and that's at paragraph 80. What was said in Seraphin in the Court of Appeal, the Supreme Court at paragraph 65 within the Lords, and the discussion during the passage of the bill, Lord McNally's speech to the effect that Section 4 was to send a signal to the courts and practitioners to make clear that the risk of make clear that the new defence should be applied in as flexible a way as possible in light of the circumstances. Well, the relevant circumstances are the matters that I have briefly addressed the court on today concerning the full factual background to the claim and the way it was, the full factual background to the tweets and how they were perceived and then written about by my client. And going to repeat the point to do with dishonesty, another reference from Doyle and Smith, my lord, at paragraph 85, journalists will be allowed considerable latitude for decision making as to the manner in which they present the facts, and allowances must be made for a degree of exaggeration. However, this isn't that's the quote, and then my lord went on to say that this doesn't extend to deliberate fakery. Well, if it is my learned friend's case that this is deliberate fakery, that in effect this article has been written not because my client has any belief, reasonable or otherwise, in the public interest of the statement of what he said about the objectionable behaviour of the claimant, and for that matter, Miss Oberman, then set that out in the reply and explain why it is that the case is said to be one of fakery. And it then sets up the issue for determination as a matter of procedural fairness, if nothing else. It isn't suitable for it to be dealt with on the summary determination, and even less is it suitable to be dealt with where it wasn't addressed in the original application and it's now raised by way of a further argument on appeal. So
you've showed us the application notice.
Yes.
Obviously, you were there. We weren't at the hearing.
Yes.
What arguments, if any, were addressed to the issue at the hearing?
Well, I responded to the extent of the case against me as articulated in the written case, because from memory, my learned friend didn't deal with it in oral submissions.
Well, he didn't deal with Section 4 in oral submission.
Not as far as I recall. And if I am wrong, the reason for that, my lady, is because it took up minimal time.
Yes, people's attention was focused on the question, truth, and sections 2 and 3.
Correct. What I did say is that the proposition within the written submission about contingency was wrong, and I had understood that my learned friend had accepted that was wrong, but by the reply. And that, I'll be corrected by Mr. Stables, but that I suggest is a fair summary of all that was taken up with consideration to do with Section 4. It wasn't even clear to those instructing me if it was a matter that would be taken forward at the hearing, because of the until we saw the skeleton argument. Now, mindful of the time, the final point I will make is this, that as was said by Mr. Justice Nicklin in the Hijaxi and Yaxley-Lennon case, Section 4 is developing area of law. It's at tab 13, but my lady needn't turn it up. I would not have considered it appropriate effectively to dismiss a public interest offence raised by the defendant only on the summary assessment of its merits. And there was reference to Lord Justice Chadwick's decision in Farah and British Airways, and that is at paragraph 12C of the 12C3 of the Hijaxi case. The only point I make there, well, I make 2 points. That I suggest is correct and is borne out by the facts of this case. I don't say that it is, as I mentioned before, in response to my lady's question, I don't say it's an absolute rule, because there will be cases which fall on the side of the divide that the court can be comfortable that summary assessment is suitable. What I do say, and it's consistent with the position as it was under the old common law defence, and I include at tab 4, Sivier, Warby and the Charity Commission, and what is said there at paragraph 22, is that in this particular case, it plainly wasn't suitable for summary judgment. What should have happened if this was an issue that the claimant was wanting to proceed with is that the extent of her case should have been developed below. And the timing is important here, my lords, my lady, in as much as the case that was heard by Mrs. Justice Collins Rice, I will check, I think it was the 6th of December, the Yaxley-Lennon case decided a month before, and of course my learned friend was involved in that case. He'd produced an extra skeleton argument in response to my skeleton argument shortly before the hearing in front of Collins Rice. So it was perfectly available to the claimant if she wanted to raise these points, and she chose not to. I'm anticipating really the further points I'll make in terms of the fairness of being able to raise these by way of the respondent's notice, but my primary argument concerning Hijaxi and Yaxley-Lennon is that it applies in this case. This is a matter which the court below, and for that matter, this court, cannot safely adjudicate on without hearing from the claimant as to what he says about his reasonable belief and decisions which the judge trying the matter will then reach concerning that belief and whether or not it was reasonable. So having taken longer than I'd initially suggested, that is a...
We did interrupt. Can I just ask one more question before you sit down? In her paragraph 68, I think it is, the judge, just call it up, the judge gave her reasons for striking out this defence, as you point out very concisely. She talked about some clear explanation and justification. There can be no reasonable belief in the public interest without some clear explanation and justification. None appears here. And you've just told us, well, we don't know what the explanation might be because we'd have to go to trial to find out what Mr. Sivier says about it. She seems perhaps, well, one interpretation of what she's saying there is that she was saying if Mr. Sivier wants to explain how he reached that conclusion, then it's for him to do so in his defence. What do you say to that?
Well, firstly, I don't know if that is what she was saying, because the extent of the case before her was, as I've already mentioned, but I accept, my lord, as I accepted in response to my lady's question, that the issue to do with truth does bear on the matters under Section 4, but of course it doesn't bear.
No, I mean, I'm asking a different question, I'm sorry. The question is it not the case that a defendant should explain how it is that he formed the view that it was in the public interest to publish what he did?
And that, my lord, is, I suggest, what is said within the Pleaded, because he addresses within his pleaded case the parts of the statutory test. Yeah. And he goes, I know that we looked...
But I think the short answer is sufficiently pleaded in this case.
Yes, that's right. And he... and just to add to that, my lord, the issues to do with editorial judgment, which are addressed at paragraph 41, my understanding of my learned friend's very detailed skeleton argument is that those aren't dealt with specifically. As I understand his case, he takes an overarching point, which is to say that the defendant is dishonest, so none of this is available to him. I suppose that this will be my final point. Having, as we do, this dispute to do with dishonesty raised in this way before this court, it only reinforces the point which I've made throughout, that this is eminently unsuitable for summary determination.
Could I just ask one more question, which is we don't have in the bundle the decision of Justice Nicklin.
Yes.
Do you have a copy of the decision? I think it may be that it hasn't been transcribed. It was a extemporary judgment, was it not?
Yes. No judgment.
I think, and my learned friend reminds me, and there was actually some toing and froing afterwards to establish exactly what his lordship had decided the meaning was. So we don't have a judgment, I'm afraid.
No.
Thank you very much. Yes.
My lady, my lords, I hope, so far as time is concerned, that I can assist everybody in the sense that I have relatively brief submissions to make, I don't propose to go to more than two authorities, to take the court to more than two authorities. So I hope I can scamper through this in 15 minutes or less. I have four heads of submission. Firstly, submissions in respect of Mr. Mitchell's procedural objections. That is to say, he makes clear that he doesn't believe that the respondent's notice should be heard at all. Secondly, the question of summary determination of Section 4 defences generally, and then more particularly in this case. Thirdly, submissions concerning the facts of this case and the application of those facts to the Section 4 defence. That is really the centre of gravity of my submissions. And then fourthly and finally, I'll make some brief points, and they are brief, that are additional to my skeleton argument. For the most part, my lady, my lords, I am frankly content to rest on what is said in the skeleton argument. And the reason I say that is that this case in my submission is really very clear-cut indeed. Firstly, the procedural objections. I don't differ, I don't take issue with Mr. Mitchell's summary of what took place below. He's taken the court to the application notice. It's certainly true that although we sought the strikeout of the defence in its entirety, the focus both of the application and of argument below was on the defence of truth. The reason for that, frankly, was that the opinion defence was explicitly dependent on the defence of truth. In other words, if the defence of truth fell, so did automatically the opinion defence. That's by virtue of Mr. Justice Nicklin's formulation of the opinion. Section 4 was not, and I agree with Mr. Mitchell about this, Section 4 was not argued at any length at all, and the extent of the prior submissions, the extent of the skeleton, it was paragraph 71, which Mr. Mitchell has taken the court to. So that's the context.
You say it's not argued at any length at all. Was it argued?
I think the proper answer to that, my lady, is no. There was comment on it. Mr. Mitchell did make a comment on it, but my submission in that respect is really quite straightforward. The judge, whatever was said, the judge quite clearly considered it proper to strike out the Section 4 defence, and she did so at paragraph 68 of the judgment, as my Lord Justice Warby has pointed out, in what we accept are sparse terms, but it was struck out, and it is clear enough from the sentences that were used by the judge below, that she considered it unsustainable as to put it in very general terms, unsustainable as a defence, and it's unsustainable on its facts as much as on its pleading. Now, just very briefly, the question of the relationship between Section 2 and Section 4 I'll deal with very briefly. Well, I'll deal with that slightly later, but I will say at this point, it isn't Mr. Mitchell's characterisation of my client's objection to this is not right. It's not a matter of Section 2 automatically bringing down Section 4, that is to say, a strikeout of Section 2 necessarily disposes of Section 4 as well. It's that they both rely on a platform of fact. That's the point. It's the operative word in paragraph 71 of my skeleton below is incapable. That's the bit that matters. What's in summary on that point, I suggest, is that Mr. Mitchell's argument goes astray on the basis that he concentrates on the defences being separate in law, but overlooks the common basis of fact. That's where I suggest the argument really lies. The respondent's notice, we're nowhere near Ladd and Marshall here. There's no new evidence put before the court. There is simply argument that, had it been sought, would have been made before the court below. In that sense, these are pure points of law. They're not. There's no new evidence adduced. An authority Mr. Mitchell cites, Notting Hill Finance and Shake. I won't take the court to it, but at paragraph 28 of that judgment, it is made very clear that the Court of Appeal is far more likely to allow in new arguments of pure law than it is other new material. And this isn't pure law. This is the application of the defence, the statutory defence, to the facts, all of which were before the court below and all of which are before this court. I just finish on this point by saying that the defendant has had ample opportunity. My skeleton argument in respect to the respondent's notice was lodged and served 6 weeks ago. And in fact, the paragraph 19 statement that was submitted in respect to the permission to appeal also foreshadowed these arguments. So there's nothing new in that sense about them. In sum, therefore, on that first head, I see no reason why the court should not accept the arguments made in the respondent's notice, both in the skeleton and orally now.
Well, the argument is it's really not very satisfactory for us to. I mean, the Section 4 is relied on as a defence below, and as you acknowledge, the judge dealt with it in short terms. There was no argument addressed to her on it, not really to be found in the application notice either. And our purpose is to review what happens below and not to, as it were, look at the matter effectively afresh. That's the argument that's made against you.
Indeed, my lady, I can't. I accept, as I began, by saying that the argument below was very limited indeed. But paragraph 71 of my skeleton below made the point to the court, and the judgment records at paragraph 12. Mr. Stable says that if the factual allegation is not, this is paragraph 12. I'm so sorry, of the judgment below. It's page 100 of the core bundle. Mr. Stable says that if the factual allegation is not defensible, then the honest opinion and reasonable belief defences fail. Also, if facts are incapable of being shown to be true, and again, incapable, I suggest, is the significant word there. There is no arguable basis in law for sustaining an opinion based on them or a reasonable belief in publishing them in the public interest. So whether that was drawn from the very limited discussion of Section 4 or whether it was taken from that part of my skeleton argument, the judge clearly turned her mind to this on the submission made. So it was before the court below, but it was not argued fully. I do, my lady, accept entirely the point your ladyship makes. about the task of the court being to review, but the strike out of the Section 4 defence was not an unexpected event, shall we say. It was simply one that received little attention below.
Isn't the point this, that the way that you test the validity or viability of a defence of truth, and in this case a defence of honest opinion, which is contingent on the success of the defence of truth, is different from the way that you assess the viability of a Section 4 defence, because in the first case you look at everything, not just what the defendant puts forward as supporting his honest and reasonable belief. And you say, well, there's a lot more. He puts in, takes things out of context, and there's a lot more. And the judge accepts that, and she says, looking at the entirety, there's no basis for a defence of truth. But if you're looking at the Section 4 defence, as has been argued, you're looking at what the defendant knew and thought and believed at the time of publication, which may not include all those other matters. So you can't, in principle, translate one into the other just like that, because you're looking at different material.
I accept that, my lord.
And what the judge never did was to say, well, even if I was looking just at the tweets that are pleaded in the defence, I would reach the same conclusion.
That is not said in the judgment, my lord, but it is, I would suggest, is the inevitable outcome. This is perhaps the appropriate point to say this, that both the defence of truth and Mr. Sivier, the defendant's belief, leaving aside his reasonable belief, his purported reasonable belief, must rely on what my client did. I mean, it's in as expressed through a truth defence. It's the conduct rule. It doesn't matter what anyone else does. To form a reasonable belief, must be based on the facts of my client's conduct. And it's my client's conduct on Twitter that's at issue in this case. And that was all before the court below. And in fact, Mrs. Justice Collins Rice does say in her judgment, as my lady and my lords will have seen, she pays attention. Indeed, as my Lord Justice Warby drew attention to from paragraph 43 onwards, she takes into account the activities of third parties and so on. But absolutely crucially, the judge below, and it is fully argued, fully reasoned, and in my respectful submission, absolutely correct, that the argument of omission on my client's part is hopeless. It simply goes nowhere. My client did not encourage anybody to do anything within the meaning found by Mr. Justice Nicklin, or indeed any sensible, likely meaning that was intended from the words complained of. Now, if the focus must be both in respect of defence of truth because of the conduct rule, and on a rather more general basis in respect of Section 4, in other words, how does one form the belief and the reasonable belief that my client misconducted herself in these really very serious ways, it must be her conduct. Now, all of that was before the court below.
What about the articles? Because, as my lady pointed out, the way the defence seems to work is I looked at these articles by another person, which were obviously highly critical. We don't have the articles, but they're linked to in the article complained of. So I looked at those, I checked them against the tweets, that's to say the ones that he pleads, and on that basis arrived at the belief that this counter-narrative was in the public interest. Now those articles were not part of the judge's assessment of truth because they're hearsay. and they couldn't support a defence of truth. But they could be relevant, would be relevant, because they're pleaded, as part of a Section 4 defence.
In their most general terms, my lord, yes, I accept that. There is the sort of music king principles, the other rules that apply to pleading and proving a truth defence clearly don't apply to Section 4 in that way. But the articles, as your lordship says, are merely those. They are, I think I've described them as vituperative. They are most certainly, they are very, very strong attacks on my client and indeed Ms. Oberman by a different publisher and observer, different blogger. They are no more than articles. You know, if that had gone to belief, if the operation of those articles in the mind of Mr. Sivier was acceptable, or at least within the parameters of Section 4, so far as the formation of a belief is concerned, my response is that they could not possibly give rise to a reasonable belief, because they were simply the opinions and the misstatements of a different person with the same objective, that is to say, a person with who shares the same political outlook as Mr. Sivier. So if he read those and formed that view, it was not reasonable, either on its face or by reference to the well-known factors from.
But this wasn't a process of reasoning through which the judge went.
No.
And what may be said against you is, well, that's what she should have done, and she didn't do it, and we don't even have the articles before us for us to look at.
That's right, my lady. I agree. That process would, ideally, that process would have been part of a full examination of the Section 4 defence prior to striking it out. I suggest it doesn't require that level of inquiry. In other words, she didn't have that material before her, or at least didn't refer to it. I don't recall it.
Do you say that because she had the tweets, which
Yes.
you then went to check to see whether there was anything
Yes.
in what was said in the articles? Is that the argument?
Yes, it is, my lady. If the tweets show nothing, and that is the conclusion on the truth defence, the tweets show that my client did nothing wrong. It is quite false to suggest that she misconducted herself at all. The judgment is absolutely crystal clear about it.
I think that has to be your argument, doesn't it? Your argument has to be, whatever these third-party articles may have said, they could not support what this defendant said any more than the tweets could.
Yes, and those Lawson articles, they're written by a chap called Sean Lawson.
Yeah.
Those Lawson articles take a draw on these same tweets and others, but on these same tweets. It's the same story, if I can put it that way.
Yeah. So it's not an authoritative source, as it were.
No.
Of some otherwise inaccessible information.
No. There's no authority in those. There isn't any editorial journalistic process that one might take for granted with a different publisher. He's simply a chap who's I believe he lives in Uruguay and publishes on the internet. There's nothing. As I say in my skeleton argument, there isn't anything in the pleading about the reliability of why Mr. Sivier chose to rely on these articles, which are plainly partisan, personal, single publisher products.
Was it part of your argument before the judge that even if you confined attention to the tweets that were selected by the defendant, the defence of truth would fail?
Yes. Yes, it was. It
I mean, it'd be helpful to know where that was, if it was in the skeleton argument. I haven't reviewed your skeleton argument below to try and find it. Don't need to do it now.
I should check it, but I believe the answer to my Lord's question is yes, it is in the skeleton argument, but it was the point was put to the court below that whether one takes the selective tweets pleaded by the defendant, or one takes the contextually more wider selection of tweets that are referred to in the annex, it doesn't matter. One can even serve them up with important ones missing. It still doesn't make out a truth defence, and I suggest it doesn't get anywhere near to providing a reasonable belief either. On the subject, on the second of my heads of submission as to the summary determination of Section 4 defences, just generally and very briefly, twice, that is once at the permission stage and once in the supplementary skeleton argument, i.e. Here today, Mr. Mitchell raises the issue of journalistic freedom and freedom of speech, and he makes reference to online policy documents. He did so again orally. Lord Justice Arnold at the permission stage said that he regarded the online policy documents as irrelevant. That's certainly my position on it also. In a case where a defendant is unable to show any wrong at all done by the claimant, there cannot be any role at all for government or law commission policy documents about online mischief. I mean, my client's done nothing wrong. She was, as the judge below, held in a respectful and civil exchange with somebody on Twitter. So this is all. I'm afraid I don't. I say this is a misplaced argument by the defendant.
Sorry, may I just put a point to you as a relative stranger to this area of law? I mean, is it in fact right that it's critical to a Section 4 defence that your client must have done nothing wrong? I mean, is it not the case that a Section 4 defence could in principle be run in a situation where there hasn't been any wrongdoing at all by your client, but subjectively and on the basis of the material available according to his understanding of the statements made, it was in fact possible and reasonably possible to form a conclusion?
My Lord, I think that's right. It would be a rather odd case, I suggest, but it is conceivable.
Yes.
That a publisher could have completely misconstrued facts, or possibly even have been misled by a source, or had simply misunderstood the papers that he or she had access to, I suppose. But the answer, the reason it would be very, what is less easy to conceive of is such a defence succeeding, because when one reaches the stage of reasonable belief, one would then be testing the extent of inquiry. What did the publisher do? Why did they misunderstand the papers? Why did they trust the source? Why did they not seek corroboration and so on? But in principle, I agree that one could mount the defence. I simply think it would be a very feeble one.
Well, I thank you. I accept that, and I can see all the problems in the way of such a defence. But the difficulty perhaps we have here is the matter was dealt with in such short order below, both in the arguments and in the treatment of it by the judge, that we have to be very cautious, I would suggest, before accepting that a strikeout is the right conclusion. I mean, strikeouts are meant for cases which are hopeless and should not trouble the time of the court. And to reach that conclusion, one has to have a solid basis for doing so. I'm not necessarily saying there isn't such a solid basis, but it's quite a strong thing to do on the strength of one sentence in a judgment and no oral submissions, when we're dealing with a defence which is conceptually entirely different from Sections 2 and Section 3 of the 2013 Act, and which has been pleaded after all. I mean, can we really be confident this is such an obviously no-hoper of a case that it should be cut short without going to trial?
In my submission, my lord, it is so obviously a no-hoper. That's my brief response to that
Yep.
point. But I do accept the other points your lordship makes about the caution that the court will wish to act with. But I suggest if one looks at the facts of what Mr. Sivier pleads he had available to him, on any basis, he could not have formed a reasonable belief. It's simply not.
Yes.
And I suggest that is what the judge below was effectively saying.
Thank you.
In this case, I'll summarise on the generality of striking out, or summary determination at least of Section 4 cases. I accept that it is a fact-sensitive exercise. Happily for the court at first instance and now, we have all the facts. We have all the relevant facts. There's nothing here that needs to be tested and examined from a source or undercover reporting or anything else. The tweets are describe entirely the basis of this. Where one then, I suggest where that takes the argument is that Mr. Sivier, in fact, pleads no more than the examination of the tweets. My Lord Justice Warby's asked about the articles. We've had some discussion of the articles. Those could not have given rise to a reasonable belief. They are based on the same tweets in any event, or largely so, or substantially so. Nothing, when looked at by the defendant, could have given rise to that. This is, therefore, what I say, a very clear case in which the sensitivity to fact can be accommodated easily within an interim judgment, which is, how could he, I mean, frankly, in simple terms, how could he possibly have reached a reasonable belief by looking at tweets which show no more than a perfectly normal civil exchange and further tweets which don't mention the child or contain any of her, or the 16-year-old girl, Rose, or contain her details. I won't go back over those points that Mr. Mitchell raised about being dragged back into the fray and so on. They were all disposed of perfectly properly in the course of the striking out of the truth defence. I mean, they've all been examined. They simply do not give rise. They're not capable of giving rise to a reasonable belief in the very serious allegations made. Finally, under this head, I just draw attention to Mr. Justice Nicklin's comment in Hijazi. It's at paragraph 25. I won't take the court to it, but he does warn, in the context of pleading, he does warn in that, his lordship does warn in that case that if pleadings Section 4 pleadings are not adequate, they are possibly heading, I think he calls them the consequences of deficient pleading. So it is plainly been in the mind of the court and has been recorded in a judgment that some form of summary disposal is going to be available in certain cases, and this, I suggest, is one of them, not only on the basis of the facts but also on the basis of the deficiency of the pleading. I'll move quickly at that point then to the third head of submission, which is about the facts. A great deal of this, I suggest, has already come out through the submissions and questions, but I reiterate the point. The defendant pleads at paragraph 41 of his defence, his amended defence, that he examined the tweets of the claimant and of Rose. That's what he says. He didn't say anything else, but nevertheless, I'm quite content to take it on a wider basis in any event. And it could only be, I repeat the point, it could only be the claimant's conduct that could go to his reasonable belief. Nothing else there. Therefore, and I might just say I'm aware that the court would have seen it, but the annex begins at page 114 of the core bundle. It runs to page 129. The shaded rows are those tweets pleaded by the defendant, and every tweet that was sent by my client is in a shaded row. In other words, sorry, every tweet that my client sent and is pleaded by the defendant is in that annex. So the entirety of what he relied on for his Section 4 defence, and indeed his other defences, are in that annex.
That's an exhibit or an appendix to Mr. Lewis's statement. It's also the appendix to the judgment.
Yes, it begins at page 114 of the core bundle. It was appended by the judge, presumably, to demonstrate explicitly the facts of the case. And I, under this heading of fact, I do stress this point that none of these facts are in dispute. I mean, these are tweets that were sent, publicly available, could have been captured at the time, presumably were, or at least the defendant pleads that he examined the tweets, so one must assume he read them. None of this is in dispute. There's no contest over the facts available. We just say, well, if one takes all the facts, the Section 4 defence fails, not least on the basis of reasonableness of belief, and there is no further inquiry into the facts need be made.
Might Mr. Sivier be entitled to say, well, look at page 122, tweet number 44, where we have Rose alleging that the claimant did all these things, encouraged a pile-on and so forth. True, he might say, the judge has concluded that that isn't in fact what happened, and that Rose was misleading herself or was misled by others into forming that view, as a matter of fact. But when I said what I said, I was entitled to rely on what she said.
He could have done that, my lord. He didn't plead it. It's not a shaded row. That was not pleaded. I suspect the reason that it was not pleaded, I speculate, obviously, is that it's not a very pleasant tweet. It shows Rose in a less than flattering light because she goes back onto Twitter and she complains about my client, and it didn't assist Mr. Sivier's case. That I speculate. Perhaps he never saw it, but for the purposes of a Section 4 defence, if he hadn't seen it, it's irrelevant because it's got to be what he knew at the time of publication. And if he did see it, he didn't plead it, so he doesn't rely on it. But I accept there is clearly a space within Section 4 for defendants to be mistaken. It's a question of whether they're reasonable in the belief they came to. You know, what gave rise to the mistake that they came to. There is a practical matter here, which is that if in January 2019, which was soon after these Twitter events, which date from, broadly speaking, the middle of December to the first 2 weeks in January, 3 different occasions, 4 if one includes the cat tweet. It would not have been a great deal of work to sit at a computer and find a tweet. There's nothing. There's no obvious reason here at all why the defendant might have misled himself. He could have looked for as long and in whatever way, whatever form of search or whatever he liked. There's all sorts of tools to do this. It's simply not a case in which there might be argument over the difficulty of teasing out facts from otherwise closed institutions or whatever. They're all online. You simply have to look for them. And when he did find them, they simply don't add up to anything that could form a reasonable belief. I'll conclude I'll move to the fourth very brief head of submissions, which is some very small additions to the skeleton, the arguments I make in my skeleton, my replacement skeleton argument. In respect to section 4.1a, that is to say whether the article was a publication on a matter of public interest, and as an associated question, whether the words complained of in an intended meaning formed part of that. I cited at paragraph 19 of my skeleton a paragraph from Doyle and Smith. It's Doyle and Smith at 64, paragraph 64. And what I didn't do, and I should have done, was in fact to cite the first sentence. It begins with 3 dots in my skeleton, and that first sentence is a sentence of my Lord Warby in that Lord Justice Warby in that case. And what is said in that first sentence is this: the requirement in section 4.1a is not that the statement complained of has some relevance to or some bearing on a matter of public interest. Now, I read that as I mentally supply the word just or only or something similar. So the requirement in section 4.1a is not just that the statement complained of has some relevance to. That's its meaning. The reason I draw attention to that is it encapsulates, I suppose, very nicely the argument that I make in my skeleton argument at paragraph 22. If one examines the article, Mr. Mitchell directed it to us in his submissions. It's at page 160 of the core bundle. From the headline onwards, the headline "Serial Abuser Rachel Riley," etc., and it goes on. Through the article, it is simply an attack on Rachel Riley. It's all completely false. I mean, we know that. The truth defence has failed utterly. It's all completely false. But it is an attack on Rachel Riley. It is arguable, I suggest it's argued as being on a matter of public interest. Frankly, in contradiction to that first sentence from Doyle and Smith, it is related to a matter of public interest. It isn't on a matter of public interest. It doesn't deal with it. It simply deals with wholly unsubstantiated and false allegations made against my client. So I suggest that the Section 4 defence fails, and it doesn't require. I appreciate entirely that this was not argued below, but I'm suggesting.
But what might have been argued is that it starts with reference to public statements made at Miss Riley's instigation in the media about herself, and then says, paragraph 7, I'm going to comment on this. Then it says she's a serial abuser, and everyone agrees that part of the meaning is she's a hypocrite. What she's been saying publicly is inconsistent with her conduct on Twitter, and what she says on Twitter is public. So why aren't those two matters of public interest? What she says through The Guardian and Channel 4 and The Times, and what she says on Twitter.
Well, I accept there is no there is no easy answer to this. The answer requires a certain amount of analysis, if I may put it that way. But it's not in my submission. It's not an article that questions anything that my client has done or said or campaigns for, and it says nothing about the complaints she makes, my client makes, about threats to her. It simply sets out to attack her. That's all it does, is it says the hypocrisy emerges from these false allegations. Now, if that test within Section 4 can be met by that way, then it's met. In other words, if one can publish wholly false allegations which relates to a person in the public eye who has taken a particular stance, which is, I accept, small p political. In other words, that context is within the sphere of public interest. Then the test will be met. But I question whether it is the operation of Section 4.1a to say, oh well, yes, you can pass this. This test can be passed by a defendant if they simply set out falsely to attack somebody who is their political opponent. That seems to me not to be within the scope of public interest as this court discussed it in economy. I suggest there's got to be rather more to it than that. It's got to be anchored in something that could genuinely be felt to be within the public interest. However, I deal under this head also with this question of honesty. What I say in my skeleton argument, this is at paragraph, I think it's 38, I'm sorry, of my replacement skeleton argument. Yes, it's paragraph 38. An assertion as to belief in the public interest must be genuine, i.e. honest. And then I reuse the term honesty. So facts known to a defendant conflict with such a belief will weigh heavily against honesty. A defendant may have a limited fiction fact honest belief. And then I go 39 onwards, talks about the genuineness of the belief. The honesty that I'm raising here is not a matter of the tests that fall within, I think it's, here we are, yes, it's the tests within SOFA and Swiss independent trustees, or any of the other pleading issues that concern dishonesty and so on. My point here is that I use that term solely in the sense that it's used in the Act itself, Section 3, in the sense that Section 3 talks about an opinion that could be held by an honest person. In other words, did Mr. Sivier, if he formed this belief, did he strain so hard to get there that he shut his mind to other things? He didn't consider properly what these. He was so eager to reach a conclusion he agreed with. Is that's all that's intended there. It's about the genuineness of it, whether it can truly be said to have been the belief in the mind of the defendant.
As I see it, but please tell me if I've got this wrong. I mean, we're not really in the area of the strict rules which apply to the pleading of allegations of fraud or dishonesty. No. The point being that this is a defence which is being relied on, and you, of course, are seeking to rebut that defence, and in order to do that, you would be entitled, if this matter went to trial, in cross-examination, to put it to Mr. Sivier that he had not been acting with complete honesty or integrity in writing the article in the way he did, and provided you had proper grounds for putting that point to him, nobody, I would have thought, would take you up short and say that you can't ask that question because you never pleaded it. That's the boot is on the other foot. It's the defence which has to be put forward under Section 4 by Mr. Sivier, and you can defend yourself against it in any way you consider appropriate.
Yes, my lord. I agree. The question, presumably, I suggest this really doesn't need to go to trial, but if it went to trial, one would imagine that the question would be, you didn't honestly believe this, or you didn't genuinely or truly believe this, did you? I mean, it's in that nature that the word is used. I say something. Well, there is another detail here which is related to the fact. So I'll deal with it very briefly. Paragraph 18 of my learned friend's skeleton refers to the full facts not being considered by the court below. I reject that entirely. But it goes on, by proceeding on the basis of C's selection of tweets, reproduced in the annex, the judge excluded from her consideration relevant tweets. They're not relevant. Every tweet that was put out that was published by my client, relied on by the defendant, is in the annex, every single one. The third-party tweets are neither here nor there, because there is nothing by way of either positive incitement or, I suggest, spuriously pleaded omission on my client's part to have encouraged these third parties, assuming, and this is all on the basis that the third parties did indeed act improperly, as the defendant suggests. And he finishes, that paragraph 18 finishes with, at least one of C's tweets was incorrectly dated, which appears to have misinformed the judge's understanding of the chronology, and there's a reference there to paragraph 43 and footnote 13. The facts of that are, it's right, it is misdated. It's put in the annex as the 11th of January. It was in fact sent on the 27th, it was in fact sent on the 12th of January. So the annex is one day wrong in its dating of that tweet. That actually, that misdating actually works in favour of the defendant, because at paragraph 57 of the judgment, and that is at page 109 of the core bundle, Mrs. Justice Collins Rice said, well, if we look at the first sentence of paragraph 57, I test this against what may be the high watermark of Mr. Sivier's case. And her ladyship went on to say, I say it may be the high watermark because of the following features. And then she describes the personal friend and so on. And then some sentences down, she says, the third, Ms. Riley's tweet, this is the, in fact, it's the final, it's penultimate sentence. Thirdly, Ms. Riley's tweet of 11th January closely followed Ms. Oberman's intervention, potential circumstantial evidence of connection. Well, it was actually later than the 11th, it was the 12th. So far as the judge considered, she didn't draw any conclusion against my client from this, but in fact, that is the only fact that the defendant points to as having been an error below, and it actually works in his favour. So that there is nothing, I suggest, to interfere factually with the decision reached. I will just finish with a brief comment on the pleading. If, as a matter of fact, and I suggest that this would not be the correct decision, but nevertheless, if as in judgment the court were to say the court does not consider it could be struck out on its facts, that is to say substantively it should survive, the pleading itself needs to be struck out, and I give reasons for that in my skeleton at paragraphs 67 to 73. Now, by reference to Hijazi in particular, and Mr. Justice Nicklin's trenchant advice and guidance to litigants on Section 4 defences and how they might come a cropper, the defence pleaded in this case that doesn't tell us, and it certainly couldn't tell the court, anything of when or how or any of the other questions this evidence was available to the defendant, what he did with it, what he concluded from it, and it doesn't, as Lord Justice Warby has questioned my learned friend about, it doesn't set out an intended meaning either. We don't know what the meaning was of the words complained of that the defendant contends for. My lady, my lords, that is all I wish to make by way of submissions, unless there's anything further I can assist the court with.
Thank you very much. Yes, Mr. Mitchell.
Thank you.
Firstly, on the point to do with the circumstances in which this new case has come about, and this is my primary objection, which I will address, notwithstanding the fact that the court has heard argument on the additional points that my learned friend raises. My points really are those set out in the supplementary skeleton argument at paragraph 9, and the first is to do with the rule 5213(2)(b) and its remit, or more properly its ambit. It is confined to reasons which are open to the lower court, but which it did not rely on. In my submission, it does not assist a respondent who does not put forward their full case below, and then seeks to develop their case and expand upon it by way of appeal. It would be quite different, of course, if Miss Riley had argued all of these points and the judge hadn't addressed them. Then they would be open to her on appeal. The crucial matter in my submission is one of procedural fairness. And it's not just fairness as regards Mr. Sivier, but as I point out, he has been prejudiced by this, not least because of his funding circumstances. Had the whole of this argument been dealt with below, it might have been disposed with definitively one way or the other, and then the case would proceed without Mr. Sivier incurring all of the extra cost which he has had to in order to pursue this appeal. As I say within my supplementary skeleton argument, it's an important matter because he is a full-time carer who is effectively impecunious, and he has had to devote a large part of that time when he hasn't been caring since this judgment was handed down below in order to try to finance this appeal, and he was only in funds in order to do so last Wednesday. But as I say, the point of fairness goes more widely than that, and it's also a question of the overriding objective and duties that are owed to the court. This was not an experienced judge in this area dealing with this matter. This was a new High Court judge, and for the reasons that I've set out to do with the case of Yaxley Leonard, it was obviously the case that the claimant knew about all of these arguments and knew about all the points that she's now seeking to take. This is a claimant who, notwithstanding the order of Mr. Justice Nichol having provided for the defendant to put in evidence, which he did very shortly afterwards, the claimant's solicitor, in the week before the case was originally due to be heard, which was in October, it was postponed, put in 2 further witness statements on the 26th of October. And notwithstanding the fact there wasn't permission for those witness statements were evidence that was taken into account by the court. Furthermore, in response to my skeleton argument, my learned friend put in a response skeleton argument in the immediate run-up to the adjourned hearing, which took place at the start of December. And I
these are all arguments that may or may not go, depending on the outcome, to a question of costs.
Yes.
In other words, I'm not saying at all what the decision of the court would or could or might be, because we haven't at all reached that stage.
Yes.
But if the court were to conclude, which we're being invited to, that the Section 4 defence was hopeless, then the arguments you would raise would be relevant on the costs. But it wouldn't be very satisfactory to send it back to for another hearing for somebody to increase the costs that could be payable, and I presume you wouldn't invite us to do that.
No, I accept those points, my lady. The mainstay of my submission in respect of the availability of the arguments in the respondent's notice is the point I was coming on to, which is whether or not it is available in circumstances where, as my learned friend appears to accept, the inquiry under Section 4 is an evidential one. and it is not amenable to summary determination. As he accepts, this is not a pure point of law case by reference to those authorities concerning new points raised by appellants, and you have the at tab 9, the Notting Hill and Shake authority in this court's recent summary of the relevant considerations. For the reasons I've already developed, and I won't repeat, this is, in my submission, this is peculiarly and distinctly unsuitable for summary determination based on the information which this court has. In response to a number of other points that were raised, a confusion on my part to do with questions being asked by my Lord Justice Warby about the evidence that was before the court below. What was said by the judge at her paragraph 20 is that the table that had been produced by Mr. Lewis and then appended to my learned friend's second skeleton argument, and which finds expression in the appendix to the judgment, that to quote, the accuracy and completeness of this table are not materially in dispute. I attached for ease of reference as an annex to this judgment, and I heard full submissions from both sides to its content on a tweet-by-tweet basis. This material would be available at trial. Well, that's the point I take issue with, because what was said to the judge below is that all of the relevant tweets were not in that table, and the issue to do with the timing of the tweet, which is stated to be on the 12th and is in fact on the 11th, was also pointed out. Now that is important, because that goes to the question of the claimant's support for Miss Oberman and what she had tweeted between the 11th and 12th of January, tweets to which she copied the claimant. And particularly by the 12th, we see the tenor that those tweets have taken in terms of the abuse that was being levelled against the child in question. So, as I said within my original written submission concerning section 2, it's an important point, because the judge describes the issue to do with Miss Oberman as being the high watermark of the case, but she misunderstands the relevant chronology. So I'm not seeking, as I said before, to reopen the section 2 point. What is important and what does bear on the decision which this court has to reach today is that what Mr. Sivier will point to at trial of the matter is not just the fact that the tweets within the table are incomplete, but as he said in his skeleton argument below, in response to the suggestion that he hadn't properly pleaded his case to do with followers, his skeleton argument, sorry, his witness statement below, and the reference for that turn it up in a moment, but in essence the point he made is that a number of accounts of followers which he had seen at the time had since been deleted, and so not available to him because he hadn't copied those at the time.
Can I just, I'm looking at paragraph 41, which is your pleaded case on reasonableness of belief.
Yes, I have that, my lady.
And it says at A that the defendant's article was based on the tweets sent by and on behalf of the claimant,
Yes.
compared to those sent by and on behalf of Rose.
Yes.
And then the two articles, having compared A and B to establish the evidential basis for his article's defendant's editorial judgment. And then the claimant's statements and position as reported by the Guardian.
So So, um,
So where do we find what you're talking about now?
well, the
The what he didn't know or things that have been deleted. I can't find it in the pleading.
right. Well, the what I'm now addressing, my lady, is the fact that the material available to him at the time is no longer available, and that point isn't specifically set out here, but nonetheless, it was a matter which he put in evidence before the court below, and it will be a matter that he relies on at trial. And that issue is also to be taken into account alongside the point I've just made concerning the compass of tweets which were considered by the judge pursuant to the document produced by Mr. Lewis.
I'm still not understanding your point, I'm afraid. What the judge says in her paragraph 20 is that the appendix is a complete set of all the tweets from the claimant and from Rose. She doesn't say it's a complete set of all the tweets ever in the world that are of any relevance to this case. And perfectly clear from other parts of her judgment that she considered other tweets. So what is it that you say she didn't take account of that was pleaded?
Well,
I still don't understand that.
so
Not something that was referred to in evidence, but what was pleaded, because that's what the case was about.
So if we look, my lord, at paragraphs 19 and 21 of the defence, which deal with abuse from followers, that material isn't in the schedule.
No, it isn't, but it's not from Rose or the claimant.
But
The schedule doesn't purport to contain any of that material.
And-
As my lady's pointed out, your defence doesn't rely on it.
Well, the difficulty with that, my lord, is that the Mr. Sivier was cited as to the abuse which the claimant had been subjected by third parties, and for that matter, the judge below is obviously on notice of it because she talks about entering Twitter at peril as a vulnerable person because it's the haunt of trolls. Where that goes to, and if it's an issue to do with pleading, then that it's set out within the Section 2 defence. It will be a simple matter of tidying up to make it explicit, if it's not already clear by the introduction, further alternatively, that these were matters that were known to Mr. Sivier when he wrote his article, that was the extent of the material that he was taking into account. And we have further, in terms of the schedule omits Rose reporting that she had blocked the claimant at 7:33 on the 18th of December, which was pleaded at paragraph 20. Now, it might be said against me, and I expect this will be the case, and that there are other examples I can give. Well, none of this makes any difference, but I suggest that it plainly does, because it goes to the material that was before my client when he wrote his article, and what was in his mind, and what informed his view as to his belief in the public interest of the statement, and importantly, as far as my learned friend is concerned, because he will say that that's wrong, whether or not that was reasonable. Now those important details were, although they were before the court, because we had them attached to the appendix to my defence, they don't appear to have been considered by the judge on the basis of her understanding of the selection of tweets presented by the claimant's solicitor. So the evidential picture is incomplete, and that's a matter which can only be properly addressed at trial. There is then the issue...
well, Mr. Mitchell, look at paragraph 61 of the judgment, would you? you've just submitted that the judge didn't take account of Rose tweeting that she had blocked the claimant. And in paragraph 61, she refers to a primary fact pleaded, which is that Miss Riley was said to have taken action to circumvent that block, and she rejects that because she says that's an impossible inference.
Yes.
So how can you say that the judge ignored the point?
Well, we're talking at cross purposes, my lord. I'm addressing the evidence which the judge says in terms at paragraph 20 she took into account. And notwithstanding, I mean, she heard full submissions on me, and I specifically referred to our own appendix to our defence, because of course it dealt with matters that aren't included within Mr. Lewis's document. Notwithstanding that, my lord, the judgment records in terms at paragraph 20 that the accuracy and completeness of the table are not materially in dispute. Well, yes, that is right, save for the issue to do with the wrong date of the tweet on the 11th and 12th. What was in dispute, and this point was made quite forcibly on my behalf, was that that was not a full record of relevant tweets.
No. So your submission is that paragraph 20 is saying that all the information I took into account, and the only information I took into account, is the information in that appendix.
Well, in so much as it says, my lord, the preceding sentence reads, by reference to my learned friend's argument, that fair characterisation of the tweets he wants to rely on, the accuracy and completeness of this table are not materially in dispute. My point, my lord, because of course I suggest we can't resolve this definitively. My point is that there is a difference on Mr. Sivier's part as to whether or not that is a correct statement. And given the matters that I've touched on, what is said within my original skeleton argument at paragraph 28 about tweets which don't find mention within the schedule and aren't otherwise referred to in the judgment, this is the incomplete evidential picture upon which the judge proceeded. And clearly, Mr. Sivier's state of mind, when he, and I appreciate there isn't evidence to this effect, the reason there isn't evidence to this effect is because effectively the burden's been reversed because the point wasn't taken below. So he's dealing with it on a defensive basis by way of a response to date, a respondent's notice. I don't suggest that that was a deliberate attempt to try to avoid the burden, but nonetheless that is the effect of it, because had these points been taken squarely below, had this been set out within the application notice, even had it been set out within the skeleton argument, Mr. Sivier would have come back in the time available, I suggest, and explained some of the points which I'm seeking to now put inadequately and incompletely on his behalf by way of submission before an appellate tribunal.
Would it have followed from your submissions that you would have applied for permission to amend?
Quite possibly. The point to do with the state of the pleadings, I would suggest is this, my lady. The tweet 44, which my learned friend referred to, that is attached to the defence, and tweet 39 is pleaded at paragraph 23. If it's the view of this court, and I suggest that the rules to do with pleading under section 4, I would sound a note of caution in terms of how the law is developed in this area, given the statements that are recorded in the Seraphim judgment in the Supreme Court concerning the...
Well, I mean, flexibility in the application of the defence is one thing. You have to know what the defence comprises before you can decide whether it should be applied flexibly. Those are two different concepts.
Well,
are they not?
I
mean, I take your point, your main point, or could or perhaps should be that this is something that you would wish to incorporate and rely on by way of your defence, but it's not there.
Yeah.
And no amount of flexibility can incorporate it.
Well, it's the points set out in the skeleton argument are there. They are pleaded.
But not in support of the Section 4 defence.
Well, if a line is required, and
Well,
I appreciate my lady.
Well, if it is in the defence, then please tell me where it is.
Well, the points I have just referred to, paragraphs 19 and 21, if that is what my lady was addressing. And then the tweet at 39 is at paragraph 23 of the defence. Of course,
But it's not in this. That's in support of the defence of justification. That's really the point.
And my lady, a simple tidying up exercise would be a one-liner making clear. And in fact, it could be done more elegantly than this, given that the Section 2 defence is now no longer, making clear that these tweets, the contents of which are pleaded hitherto at Section 2 are set out now in respect of Section 4. And any other points that, any other objections which are raised today can be dealt with. Not the proper course for the claimant in this case to take is to suggest that because and only by dint of the strikeout of Section 2 does this argument concerning the inadequacy of Section 4 become live. Had the point been properly taken below, then all of those issues would have been before the judge below. And I suggest that the judge below, given her statement that that strikeout was, and I'll just make sure I quote her correctly, is a drastic remedy to ask for, as she said at her paragraph 13, doubtless because the point was before her and she would know it anyway, the alternative of amendment is something which should be considered before. So of course that's still a point that's live now, and mindful of the lack of jurisprudence in this area and the fact it is a new and developing area of law, any guidance which this court would seek to give on the particulars required under Section 4 would obviously be borne in mind by Mr. Sivier. What I don't accept is that by analogy with the Yaxley-Lennon case and what was said there about loose particulars, not least the circumstances in which that amendment application came about, that it can be said, as my learned friend baldly says, this Section 4 pleading is hopeless and should be struck out on its face. That there is more than enough information there which puts his client on notice of why it said that the statement was in the public interest and the basis on which my client formed a belief, and why he says that that belief is a reasonable one which is open to him, objectively open to him, as he will seek to demonstrate at trial. And whilst I take the points which my Lord Justice Henderson says about the formality of pleading concerning dishonesty, it does, in my submission, set up something of a striking contrast that my client can be on the receiving end of criticism below, repeated above, to do with the basis of his pleaded defence. Of course, the focus below was not on Section 4, but nonetheless, this case, which does in terms, within the say that he is a dishonest person if he seeks to rely on this defence, and no bones can be made about that, because that is the submission, that doesn't require, in the way that any other pleading, not least in the field of this area of law, would require a specific aversion to that effect by way of a reply. And I suggest if that is the case that my client has to meet, then that is what the claimant should do, accepting, of course, that can only happen after any amendment which he has to effect.
Well, you could say that Practice Direction 53B, paragraph 4.8, requires a claimant who intends to allege that the defendant did not reasonably believe that publication was in the public interest to say so in a reply and to give particulars.
And then that
So
will,
it is a matter that if the case went forward,
yes,
it would have to be pleaded.
yes. And then, of course,
It doesn't
it would-
necessarily follow that it has to be pleaded before you can strike out defence.
No, it doesn't, my lord. But as I say, it does set up something of an inconsistency, if I can put it as neutrally as that. The Section 4 particulars in this case, which I suggest are adequate, are subject to the sustained criticism that they have been on appeal, where this argument to do with honesty has not been foreshadowed at any
No, the point about when you raise a case on which you have the burden of proof is that what is said in relation to that case, whether you're a claimant or defendant, actually marks out the territory of dispute between the parties.
Agreed, yes.
And if the defence doesn't mark out the territory adequately, it's no answer to say, well, what's said in response is inadequately pleaded, because it either the defence is adequately marked out or it's not. And it's incredibly important for the progress of litigation that whether you're looking at the pleadings by a claimant or a defendant on whom the burden of proof lies, that it's crystal clear what the case is, because otherwise everything unravels thereafter.
Yes, yes.
And it leads to an enormous amount of wasted time and costs, including in interim applications.
Yes, I accept that point. The only other points subject to anything which those instructing me may want to raise, that I say these, that you'll see whilst we haven't heard much from my learned friend about statements on matters of public interest, I won't read them out, but the court will have them in mind. What was said by the judge below at paragraphs 54 and 55 about the nature of the publication and about the effect that it had on the child victim, the effect of trolling and the world of Twitter, and how vulnerable should enter at their peril. That, in my submission, very much reinforces the first consideration under the Section 4 defence. My learned friend said that the article does not discuss the threats to the claimant. Mr. Sivier is specific and careful in his article. The first portion of it, paragraphs 1 to 6, quote directly from what the claimant has said regarding the treatment to which she has been subjected. He sets that out fairly. Moreover, in terms of the actual narrative and counter-narrative of his article, he has to set it out in order to challenge the theory. So I disagree with my learned friend's characterisation. And finally, to echo what was said by my Lord Justice Henderson, the strikeout jurisdiction is a draconian jurisdiction which should only be reserved for those cases which on their face are plainly hopeless and should not take up any further resource of the other side or the court. This obviously is not such a case, not least for the reason my Lord posits, which is that Section 4 defence may be available to someone notwithstanding the veracity of the matters that he or she speaks to. Now, I am not there conceding that what Mr. Sivier said was not something which he was able to do within the parameters of Section 4, and I'm not seeking to revisit the Section 2 defence. I simply make the point that there is clearly, not least in a matter as where, as the judge records at 53 and 54, a debate as controversial as the debate concerning the claimant and the child. In this case, there is clearly the scope for different impressions and for different views to be held by different members of the audience, and importantly, to be put forward by different commentators. And at trial of the matter, Mr. Sivier will seek to develop and explain why it was that he held this belief in public interest, and why he says that it was eminently reasonable. That those are all matters which can only be determined at trial of the matter. Unless I can assist further, those are my points.
We'll just rise for a moment. Thank you.
Court rise.
Mr. Mitchell, Mr. Stables, thank you very much for your helpful submissions in this case. We will reserve our judgment or judgments. Draft will be circulated to the parties in the normal way for correction of spelling or other typographical errors, not for re-argument, obviously. The handing down of the judgment will be done virtually. There will be no need for the parties to attend. If there are consequential submissions as a result of the judgment, could they please be provided in writing? But we would is to endeavour to agree a draft order for the approval of the court before the handing down of the judgment in its final form, the judgments in their final form. Thank you very much. We'll rise. Thank you.
Court rise. going to stop the live stream now, but for 90 seconds it will be broadcasting. So once again, anything you say